Hello everyone, this is Suresh Ramani. I am a science graduate and I am a technology professional. I was fascinated with law, so I decided to study law formally. It was a fantastic experience and I would definitely want to share some of the great learnings I got with my friends using the digital medium. One of the most fascinating subjects in my study of law was Indian Constitution. I was blessed to have fantastic teachers and I was absolutely in love with that subject. I firmly believe that many of the ills of our society have got an answer, a cure in the Indian Constitution. So over a period of few videos, I'm going to share some of the important articles of Indian Constitutional, especially in the area of fundamental rights. So this first video is all about an overview of what are fundamental rights in India. So let me quickly share my screen, share my deck rather, and get going, right? At the end of it, do share your views on the video. So that will tell me what I need to do to make it more engaging for you. So it's an overview of the fundamental rights. Let's understand the concept. Since the 17th century, human thinking has been veering to a theory that human beings have certain essential, basic, natural, and inalienable rights or freedoms. And it is a function of the state in order that human liberty may be preserved, human personality developed, and effective social and democratic life promoted, to recognize these rights and freedom and allow them a free play. Further, it has come to be regarded as desirable that these rights be fortified in such a manner that they may not be violated or interfered with by any oppressive government. These rights are characterized as basic or fundamental rights. In modern times, people's basic rights have been given a more concrete and universal texture by the Charter of Human Rights enacted by the UN and the European Convention on Human Rights. The modern trend of guaranteeing fundamental rights to the people may be traced to the Constitution of USA, which was drafted in 1787. Justice Jackson explained the nature of fundamental rights in this way. I want you to read this very, very carefully. What he says is that the purpose of the rights is to withdraw certain subjects from the scope of politicians and to establish them as legal principles which will be applied by the courts. The right to life, the right to liberty, the right to property, the right to freedom of speech, a right to free press, freedom of worship and assembly. These rights cannot be changed by a vote, which means that the government of the day cannot change them. I think it's one of the best explanations of what fundamental rights are all. The fundamental rights in India are enforceable against the state by any aggrieved person. So if they are enforceable, it means there should be certain articles which give teeth to the fundamental right. Article 13 is the article which gives the teeth. Article 13(1) declares that all the pre-constitutional laws, the laws which existed before Constitution, like Indian Penal Code, Contracts Act, shall be void to the extent of their inconsistency of fundamental rights. If there is any clauses which are inconsistent, then they will not be applicable post 1950. Article 13(2) states that the state will not make any law which either takes away or abridges the fundamental right, and the law contravening the fundamental right to the extent of contravention is void. What is the meaning of this? That the term law, first of all, has got a very wide meaning. It includes ordinances, orders, bylaws, rules, regulations, notifications, customs, usage, everything. So it declares and imposes an obligation on the courts to declare a law void if it is inconsistent with fundamental rights. So the classification, we have the right to equality, which is Article 14 to 18. We have a right to freedom, which is 19 to 22. Right against exploitation, which is Article 23 to 24. Right to freedom of religion, extremely important, Article 25 to 28. Cultural and educational rights, which is Article 29 to 30. We will cover some of these over the next few videos. Another classification could be for Indian citizens, which is 15, 16, 19, 30. So non-citizens cannot take advantage of these. Then for everyone, it is Article 14, 20, 21, 22, 23, 25, 27, 28. Here, whether you're a citizen or a non-citizen, it does not matter. You can definitely expect that the fundamental rights will apply to you. Some important doctrines which have emerged. First is the doctrine of eclipse. Now, Article 13(1) is prospective. It means that any law which is in existence today, which is passed before the Constitution came into picture, then the portion which is not in sync with the Constitution is void. However, any law passed after the Indian Constitution came into picture, if it is void, then the question doesn't arise because it's void from day one. So here we have one case law, Keshwan versus Bombay. Here the person was getting prosecuted under a law in 1951 after the passing of Constitution. Now when the law, his act was before 1950. Okay. However, Constitution made his act legal. How it was held that this article cannot apply to him as the offense was committed before the passing of the law. So that's very important to understand that. Article 13(2) states that the state shall not make any law. What does it mean? That you cannot make any law which is against the Indian Constitution. Next, let's talk of doctrine of severability. According to this, if any law is passed and if a portion of that law is not in sync with the Constitution, then only that portion is invalid. The rest of the law is valid. So here we have a Kameshwar versus Bihar as one of the case laws. However, please note that if the full act, you cannot remove that portion, invalid and valid portions, then the full act becomes invalid. Doctrine of waiver is very important. Now the question is, can a person waive off his fundamental rights and say, okay, listen, I'm waiving off my fundamental rights and they don't apply to me? No, you cannot. Very, very clearly, no person by any act or conduct will relieve the state of the solemn obligation imposed by the Constitution. That's point number one. So effectively, none of the fundamental rights can be waived by a person. So even if you want to, you can't waive it. Fundamental rights are applicable whether you like it or not. I do hope that you found this overview of Indian Constitution fundamental rights useful. Over a period of next few episodes, we'll deep dive into some of the most important articles which are absolutely wonderful. So keep watching and have a wonderful day ahead.